crimes can be prosecuted both in the federal system and the state system. So it brings up the necessary question, what is the difference between the federal system and the state system? There are many, many important distinctions. Probably one of the most important ones deals with the plea bargaining system. In the state system, you can bargain for a particular sentence. For example, it's very common to bargain for, let's say, a sentence of 4 years. The state agrees, the defense agrees. The judge does not have to go along with that, but quite candidly, the judge in almost every single case where the prosecutor and the defense agree to a sentence will go along with it. But here's where the big distinction is. If the judge does not accept the plea bargain in the state system, the defendant's allowed to withdraw and start from ground zero. Doesn't work that way in the federal system. First of all, in the federal system, you do not negotiate for a specific term, except for in the most rare of situations, and I will get into that in a moment. But generally, all you do is agree as to what counts you're going to plead guilty to. The government agrees to dismiss the remaining counts, and you may agree to how certain guideline computations apply, but those are not binding on the court. So if somebody enters a plea bargain in the federal system, most of the time they do not know what their sentence is. They have to await sentencing, and there's a broad range that the judge could give them, and if they do not like the sentence they receive, they are not allowed to withdraw their guilty plea like they would be allowed to do in the state system. Another big distinction is the federal sentencing guidelines. In the state system, a certain crime may carry, say for example, a maximum punishment of 20 years. The judge could give somebody anywhere between 0 and 20 years. Federal system is similar in that the judge could give anywhere between the minimum 0 and the maximum of 20. However, as a practical matter, they must first go to the federal sentencing guidelines. And the federal sentencing guidelines try to score offenses and to come up with sentencing guideline ranges. Now, the purpose of the federal sentencing guidelines, at least in theory, is to provide equal sentences to equal defendants without regard to what their race is, what their income level is, what their standing in the community is, whether they're white, black, rich, poor, etc. And although this is a laudable goal, in practice it becomes quite difficult because in scoring offenses there are numerous debatable factors or enhancements that come into play. And you never know what those enhancements are going to be for sure all the way until the day of sentencing. And then a probation officer will prepare a report that will have a guideline calculation. And both parties can object to that. And ultimately it's up to the court to decide what the correct guideline is, what the correct sentencing range is, and then even at that point the judge can give more or less than that called for in the guidelines. If I had to summarize the basic differences, it would be that in the state system there's certainty. You know going in what kind of sentence you're going to get. It can be negotiated. It can be negotiated with certainty. In the federal system, you're not going in blind, but you're going in close to blind. That is that there are many different ways the sentencing guidelines could come out. Their judge could give more or less than whatever it's determined to be, and you do not have the right to withdraw the plea. So it's extremely risky in the federal system working out a plea bargain if you would like to know, as most people do, what specific sentence you are going to receive by the court. Whether you are under investigation for a federal or a state crime, it is important that you seek an attorney experienced in handling criminal cases. I've been handling criminal cases as both a prosecutor and a defense attorney since 1978. And I've been on the defense side from 1987 to present.